Hi viewers, you are well aware that I am the Professor Dr. Jedning Ellosa, running a YouTube channel called Law Speeches in three languages, that is the English, Hindi and Telugu. So regularly I am posting the matters pertaining to the legal aspects and also the world affairs. So today I am lecturing on important judgments of the Supreme Court of India, which is the apex court, and also the judgments of the other countries. Because this lecture is very useful for the students, uh, persons appearing for different competitive examinations. And as you know that every day the Supreme Court of India has a empowered by the Constitution of India to interpret the Constitution. And whatever Supreme Court says that binds upon the all the lower courts. So today this is not only to here but also in other countries also the same. The wherever the commonwealth law common law principles are there, the same would be followed and adhere everywhere. So here I am discussing only the name of the case and the brief principle which is laid down in that case. The first case is the Keshanta Bharati versus State of Kerala, 1973. The full bench of the Supreme Court opined or stated that the Parliament cannot destroy the basic principles of the Constitution. So that be called as the Supreme Court has propounded the basic structure doctrine. So whatever majority the parliament may be enjoying, the party ruling party is enjoying, but they have the no right to destroy the basic tenets of the constitution. That is a very landmark judgment. Till today also the judgment is being uh, followed in a scrupulous manner. The second important case is Maneka Gandhi versus Union of India, 1977. So in this case, the Supreme Court stated that we have the right to go abroad. It is a fundamental right under the Part 3 of the Constitution of India. And for violating the fundamental right or taking away the fundamental right, the state has to follow the due process. So due process has been recognized as a is a part of the under Article 21 of the Constitution of India under the life and personal liberty. Then the third case is the Puttuswamy versus Union of India. In 2017, the Supreme Court opined that right to privacy is a fundamental right under the Article 21 of the Constitution of India. It is also popularly called as a Aadhaar case. So the state has to take special steps for protecting the right of the citizens. Then the fourth case is Bikazi Narayan versus State of MP. So in this case, the Supreme Court has elaborately discussed the doctrine of eclipse. So in which the Supreme Court held that the laws which are made which are inconsistent with the fundamental rights become eclipsed, means that become moribund condition that cannot be enforceable. Then the fifth case is Venkat Ramana versus Bank of Mysore. In this case, there should be harmonization of the constitutional provision should be there. So we can say it is a harmonizing the constitutional principles. The next case is the sixth one, Minerva Mills versus Union of India. This is a where another landmark judgment is delivered, where the Supreme Court opined that right of judicial review is a part of the fundamental right, and which we are, though in the first time we got it from the United States of American Constitution in Marbury versus Madison, but here also it has been ratified by the Supreme Court. Then the other case is the state of Bombay versus FN Balsara. In this case, the Supreme Court has provided uh, the doctrine of pith and substance, another important doctrine which provides the center state relations, legislative powers. So doctrine speaks about it, and that has been which is there in the United Kingdom, that has been again ratified in this case. The next case is Olga Tellis versus Bombay Municipal Corporation. So right of payment to dealers, the sell on the payments, small traders, their right is discussed, whether they have the right to sell their products on the footpaths. So in this case, Supreme Court stated that yes, right of livelihood is there. It is a part of the fundamental right. So state, they wanted to clear the payment dwellers, or to say the vendors, the small scale hawkers. They have to take rehabilitative measures, then only they can be removed. That is another landmark judgment. The ninth case is the Shreya Singhal versus Union of India. So in this case, Supreme Court has occasion to discuss the Information Technology Act of 2000, in which the section 66A, which is taking away our right of causing the hindrance to the freedom of speech and expression under the Article 19, was uh, suspended, and the we can say struck down that section 66A. So now it is not enforceable. Then we have 10th important case is Ajay Hasia versus Khalid Ajay Hasia, then the Khalid Muzib, Sukhdev Singh versus Bhagat Ram, Rajasthan ACB versus Mohan Lal. In all these cases, the Supreme Court has expounded what is meant by the Article 12 of the Constitution of India, which provides with regard to the definition of the state. No definition, but meaning of the state, that is there under Article 12, that has been expounded by the Supreme Court. The 11th case is KC Gajapati Narayan Do versus State of Orissa. In this case, the Supreme Court has applied the doctrine of colorable legislation, and how it can be workable in India, that has been clearly stated by the apex court of the land. Then there is a 12th important case is the S.R. Bommai versus Union of India. It is another landmark judgment which speaks about the federal principles, distribution of powers between the one state to the center states. So we have the famous uh, constitutional jurist Vire. He remarked that India is not a fully federal, it is a quasi-federal. So, but in this case, Supreme Court has stated that we have under Article 25 to 19, we have the right to religion is there, but the preamble provides the inserted the secularism. So in this case, Supreme Court has stated that secularism is a basic structure. So the state has to follow, or should be the path of secularism. So that was opined by the apex court. Then 13th important case is the state of West Bengal versus Union of India. So in this case again the basic features of the federalism was highlighted, though it has Supreme Court stated that the constitution itself is a federal constitution. So there should be a clear-cut demarcation is there under the schedule 7th of the constitution. So center and state should coexist with each other. That was a principle laid down by the Supreme Court in this case. Then we have the 14th case is the Golaknath versus State of Punjab, another landmark judgment where the Supreme Court recognizes the doctrine of prospective overruling. So where the past acts uh, can be struck down by this case by the Supreme Court. Then we have the 13th important case or 15th important case is Nandini Shatpathy versus P.L. Dhani, another important case where the Article 20, Class 3, in which there is the certain basic rights have been given to the accused persons. That is, the right of against self-incrimination is recognized, and the nobody should be forced to become a witness to his own cause. That has been recognized by Supreme Court in this case. Then the 16th case is Pujapal versus Union of India. So in this case, the Supreme Court opined that fair investigation is also a fundamental right under the Article 21. So police enforcement agencies, law enforcement agencies, they have to be inquire the matter in a fair manner, not in a partial manner. So if they do it, then the courts have the right of striking down that partiality. Then we have the 17th case is the Lalita Kumari versus government of Uttar Pradesh. Then the Supreme Court has stated that FIR, first information report, is a mandatory for the cognizable offences, without which a offence cannot be categorized. So FIR is a mandatory. That was opined by the Supreme Court. Then we have the 18th case is the BP Kapoor versus the state of Punjab. In this case, the section 482 of the Criminal Procedure Code, 52, so 528 of BNSS, in which case the police has to use this section not in a regular manner, only in extraordinary conditions only they have to avail this section that was stated by the Supreme Court. Then we have the Joginder Kumar versus state of UP case. So in this case, the Supreme Court has given guidelines that when you make an arrest of a person, they should follow certain guidelines mandatorily. If not, it is nothing but violation of the fundamental right. That was stated by the Supreme Court in this case. Then we have the Arnesh Kumar versus state of Bihar. In this case, under section 498A of IPC or section 85 of BNS, where the guidelines were given that false implication should not be there. So in between the 498 days, the dowry harassment cases. So they have to follow. It has made a certain recommendations that they have to be strictly follow these guidelines. Then the 21st case is the Vinay Tyagi versus Irshad Ali. In this case, the magistrate has the power. Even if a FIR or charge sheet is filed, after filing of the charge sheet also, magistrate has a power to further investigation into the matter. That power is there to the magistrate. Then we have case number 22, so DK Basu versus state of West Bengal. So in this case, concept of custodial torture is recognized, and The Supreme Court has stated that it is a violation of the Article 21 of the Constitution of India, the fundamental right. Then the 23rd case is State of Haryana versus Bhajanlal. So when the courts have the power to quash the first information report, that is the High Courts and Supreme Court has the power, then they have to follow certain guidelines, then only they can quash the FIRs. So that was explained in this case. Then 24th case is the Kushal Rao versus State of Bombay. So the dying declaration, which is there part of the section 32 of the Indian Evidence Act. So what is the sanctity of it and reliability of it has been discussed, and which was then this court has stated that they should follow the basic principles of dying declaration to become it is a dying declaration. Then this 25th case is Husinera cartoon versus State of Bihar. So in this case, the speedy justice and speedy investigation is a part of the Article 21. It should not be prolonged and prolonged. It should be within certain time span. The matter has to be investigated and the matter has to be dealt. Trial should be dealt. That was opined by the apex court of the land. Then 26th case is the Mehboob Shah versus King Emperor. So in this case, the section 34 of the Indian Penal Code, then section 3 class number 5 of the BNS, where what is meant by common intention, that has been explained. So there should be parties participating in that act, they have the commonly thought of it. So that has been explained in this another remarkable case. Then we have the 27th case is the State of Uttar Pradesh versus Babu Ram. So in this case, the court has clarified that motive is not essential for the conviction under the IPC or BNS. So simple motive is not essential. There should be a criminal intention should be there. Without that, they cannot be convicted. Then there is a 28th case is KM Nanavati versus State of Maharashtra. The in this case, grave and sudden provocation under section 300, which providing the murder, and explanation 19 of IPC, section 101 of BNS, presently BNS, that have been clearly stated what is meant by grave and sudden provocation. Principles have been identified by the apex court of the land. Then we have the 29th case, Reg versus Govinda. The distinction between the murder and culpable homicide was explained in a lucid manner, in clear manner. So murder and culpable homicide amounting to murder or not amounting to murder. That is the two important aspects are there. That has been intention and not causing intention. But murder is homicide was taken place. So that has been explained in this case. Then 30th case is a Lalji versus State of UP. The requirement for the section 114 of IPC, 190 of BNS, unlawful assembly, common object was explained, set out. So what is meant by unlawful assembly and what is the common object of that unlawful assembly? So all those things have been clearly dealt by the Supreme Court in this case. Then 31st case is the Veer Singh versus State of Punjab. So in this case, the court has stated what is meant by intention, what is meant by knowledge. The difference has been expounded by the case for the act of murder. Then 32nd case is the Iridium India Telecom versus Motorola company. So corporate criminal liability, whether corporates companies are liable for criminal liability or not, that has been explained in this case, and Supreme Court stated that yes, the managing directors, they are liable for if they commit the crimes under the in the use of the corporate law, corporate personality that has been. Then then we have the case number 33, SS China versus Vijay Kumar. In this case, the Supreme Court again stated that what is meant by abatement in a criminal act and what is not. So that has been clearly explained by the Supreme Court. Then 34th case is the Basdev versus State of Pepsu. So here the court has if a person does any act under intoxication, then whether it amounts to criminal liability or not has been clearly discussed by the court. And the intoxication condition, the intoxication is without any intention. If they commit the crime, that they can be excluded from the criminal liability that was stated in this case. Then we have the case number 35, Tunda versus State of UP. So in this case, section 76 of Indian Penal Code, 14 of the BNS, mistake of fact or good faith has been explained by the apex court in this case. Then case number 36, Sharad Birdi Chand Sharda versus State of Maharashtra. So in this case, the Supreme Court has provided laid down the five golden principles of circumstances of evidence. So what is meant by circumstances of evidence, and what are the certain important principles have been propounded by the Supreme Court in this case. Then case number 37 is a Kushal Rao versus State of Bombay. So the case clarified the dying declaration. Then the basing upon the solo dying declaration, the conviction can be made. Then what is a trustworthy of that kind of a conviction that has been elaborated by the Supreme Court in this case. Then we have the 38th case is the Lakshman versus State of Maharashtra. So in this case, court held that doctor certificate for dying declaration is not mandatory if the court is satisfied of fitness. So doctor should not be there for while recording the dying declaration. So the certificate is not required. If the person giving a declaration before his death, that is sufficient. Then that was stated by the court. Then the case number 39, Satpaul versus Delhi administration. So court has been here discussed the who is a hostile witness and what is the statement if it becomes hostile, whether it can be accepted or not. So all those facts have been discussed in this case. Then case number 40, Dharma Dio Yadav versus State of UP. So in this case, the court has held that the scientific evidence like the DNA has a higher probative value. So if scientific evidence is always have the higher probative value, so that has to be accepted. That was stated by the Supreme Court. Then case number 41, Shankaria versus State of Rajasthan. So in this case, the court has stated that confession must be voluntary and it should not be forced. If the confession made before police officer is not admissible, but if it is a voluntary, it can be admissible. That has been stated by the Supreme Court. Then we have the case number 42, Panchi versus State of UP. So in this case, the what is the authentication of the child witnesses? Is it reliable or not? That has been discussed, and the court has stated that yes, they can be taken into consideration if it is a truth or some sort of important thing is emanated from that kind of. Then case number 43, Kanta Prasad versus Delhi administration. So in this case, the court has propounded the test of identification parade, TIP, and which has given certain guidelines how identification parade can be made of a form. that has been stated in this case. Then case number 44, Pulukuri Kotaya versus Emperor. So in this case, evidence discovered under sections 27 Evidence Act and 23 of the BSA is admissible even if confession is inadmissible. So whatever material objects have been seized under section 27 of Evidence Act, that may be admissible, but confession may not be inadmissible. That was stated in this case by the courts. Then case number 45, Duktar Jahan versus Muhammad Farooq. So in this case, the child legitimacy under section 112 of the Indian Evidence Act, 116 of the BSA is discussed, and in this case, the court has been stated that conclusively that has legitimacy has to be proved. Then only it will be have the value. Then we have the case number 46, Darya versus State of UP. So the court has stated that res judicata principle is not only applicable to the civil law but also even for writ petitions also res judicata is applicable. That has been stated by the Supreme Court. Then we have the case number 47, Forward Construction Company versus Prabhat Mandal. So in this case also the Supreme Court has stated that constructive res judicata. What is meant by constructive res judicata is highlighted. So constructive means by basing upon our act, the res judicata can be taken. So that has been explained or expounded by the Supreme Court. Then case number 48, Arjun Singh versus Mahendra Kumar. In this case, interlocutory orders do not operate as res judicata. So orders which have been made by the courts in IS, that cannot be called as a res judicatas. That has been the principle is made down by the Supreme Court. Then case number 49, Jai Berham versus Kedarnath. So in this case, the doctrine of restitution under section 144 of CPC, Civil Procedure Code, was discussed, and the matter was clearly stated that when it has to be, the case has to be restituted. Then 50th case is the Kiran Singh versus Chaman Paswan. So in this case, the jurisdiction, which is an important aspect in the any civil law, criminal law. So the principle have been discussed by the Supreme Court, and consent of parties is required for jurisdiction or not, that has been discussed, and the Supreme Court stated that yes, it should be required. So these are the 550 important judgments which I am placing before you, and some more important decisions are there. In my next lecture, I will make another 50 important lectures, and I till then I am signing off, and I also request all of you to subscribe to my channel, watch my videos. If you feel that those videos are knowledgeable or informative, please like it, and also pass over these things, my videos, to your friends and community members. Thank you for patiently hearing my lecture. I will again back another 50 important judgments in my next lecture. Thank you, and all.